All rise.
Yes, Mr. Carroll.
Lords, I hope to be fairly brief now. The test, of course, has been identified. It was identified at the appeal court. The test, of course, has been identified before this court. But the way in which the test was applied might indicate that the court had assumed that the test meant more than it really did. And I say that because in the judgment of the court in McInnes, which is in the list of authorities, the first list of authorities, number 16. If my lords...
Sorry, where are we going to? The
first list of authorities, my lord, at tab 16.
That's just the printed version of this.
It is. It is, my lord.
Yeah. 16. It's just the printed version.
It's just the printed version.
which bundle is this?
Authorities.
Joint authority?
Yes. Tab 16. No, maybe.
I think
It's the one on the bottom.
authorities
Bottom
are
right.
rather difficult to trace.
My lord, it may be easier if we stick with the core bundle. I don't know if you've got the core volume.
It's all right, yes.
Thank you.
Number 16, which is just the print of what...
Yeah.
Yes, it's just the print, my lord.
Yes, all right.
The test having been identified, what the court seems to think, in my submission, is stated at paragraph 20 of the judgment. In the closing remarks at paragraph 20, when the court refers to the possible misreading of Lord Rodger's words, they say, we venture to think an unfair trial. And just after that, the court says, a robust test is required. Now, that, in my submission, suggests the raising of the bar for an appellant who's been denied access to information. But further indication of the way in which the court applied it may then be seen if, my lords, look over the page there to about halfway down, paragraph 22 on the following page, which is page 19 in the original printed report. The court is looking at the evidence, the withheld evidence, if you use that expression, and says, had the exit statement of 17 January been available to put to Pierce when being cross-examined in relation to who administered the roundhouse kick, that would, in its qualified form, hardly have constituted a coup de grace. Now, it does appear, in my respectful submission, my lord, that what the court is looking for here, having stated what the test is, and then said it must be robust, is then looking for a coup de grace. And that is not something that I would suggest is required in a trial, in a thin case such as this, thin on identification. All the jury may be looking for in relation to Mr. Pierce's admittedly shaky evidence on identification is something that puts them over the edge.
Tipping the balance.
Yes, it tips the balance. Yes, my lord. And in my submission, my lords, it cannot properly be said that this could not have raised a reasonable doubt. And the loss of opportunity to put that information to the witness should have been available, should have been, remedied by the High Court without the High Court looking at such high burden, really, or onus on the accused, to get beyond a robust test, which it's not suggested is a robust test, because arguably the Kelly test is in fact lower than the test in Hogg v. Clark, because Hogg v. Clark seems to suggest that the accused requires to establish that he was in some shape or form prejudiced by the loss of opportunity. Whereas in Kelly, it's just that risk that requires to be identified. And it may be that the use of the word prejudice throughout many of our reports in Scotland, the Scots law, the word prejudice has perhaps in the mind of the court elevated the obstacle, if that's the correct term, has raised the obstacle to the accused because of the notion that it's in some way a robust test and requires to the piece of evidence requires to deliver a coup de grace.
So are you saying that provided one properly understands the meaning of these words,
Yes.
real risk of prejudice would be the right test?
Yes.
But you have to understand what it really means.
Yes, my lord. When those factors, that's the identification of the test, the way in which the court viewed the test, and then the way in which the court applied the test to the evidence in this case are all taken together.
So you're inviting us to apply the test.
I'm inviting this court to apply the test, my lord, yes.
So the question for us is whether we regard the failure to disclose and all these reasons as giving rise to a real risk of prejudice.
Yes. And if the test is applied without the appendage robust and without seeking a coup de grace, then we're back to where we were in Kelly. In fact, we're even back to where we were in Hogg v. Clark, which does appear to be, and I think this is the part of the Crown's argument in this case, that the Hogg v. Clark test is perhaps a higher test and the real risk of prejudice is a lower test. So whichever test applies, it is certainly much lower in my submission than the test that's been applied by the High Court in determining this appeal. So unless my lords wish me to go into the evidence in this case to explain any further why I say that.
Well, could you just help me on the last part of paragraph 22, the reference to change of facial appearance? That's because your client had grown a beard, is it?
Well, it was said by
or if not, can you explain what that does refer to?
Yes, it was said in the identification parade report that the accused had some facial hair, because there was an objection taken to the stand-ins on the basis that the accused, the suspect, had a degree of facial hair. Now, it doesn't, with respect, it's difficult to know what happened, but it doesn't, with respect, seem likely that the police would have conducted an unfair identification parade by parading the only man with a beard. Otherwise, the lawyer present would have objected to it being a full beard, and indeed counsel at the trial, having been appraised of that information, may well have raised the issue of whether that identification parade was indeed fair. That didn't happen. And so the reference to a growth, and I think that's about as much as it went at the parade, doesn't seem to have been a growth such as to single out the suspect, McInnes, on that parade.
If we look at the transcript, which is in appendix tab 7, page 131, the last few lines, you'll see that Mr. Pearce in evidence said that why didn't he actually recognise him at the time? It was because I told the police at the time he never had a goatee beard, but on the lineup he had a goatee beard. I couldn't identify him positively, and I told that to the police. Page 131.
And that's reflected in the judgment of the appeal court, page 21.
Well, I see that, my lord, but in actual fact, on the information that was disclosed, that's the prior statements of Mr. Pearce, he doesn't tell the police that the difficulty was in relation to the goatee beard. The person he tells is a recognition officer within the Property Fiscal's office at some stage much later on, it seems.
I'm sorry, I can't hear very well.
He didn't, on the statements that were lodged, that is Pearce's prior statements that are lodged with the bundle, he doesn't tell the police that the difficulty was to do with the goatee beard and the suspect on this parade. The person he tells is in fact a recognition officer. That's a person within the Property Fiscal's office at Glasgow who takes a subsequent statement from the witness. He tells that person about the goatee beard. Now, the issue about facial hair, such as it was, would already have been raised in any event within the identification parade reports. And one of those reports was Crown Production 19 in the actual trial. So there was already a reference to facial hair. And it doesn't, with respect, appear necessarily damning that the witness would have explained that there was a change of appearance for a number of reasons. It's firstly, the suspect, Mr. McInnes, wasn't aware that he was a suspect until August, 7 months after the incident. He's perfectly entitled to grow a beard, and nobody suggested that he change his appearance. The parade itself must have been fair, otherwise one would think that an objection would have been taken. And so this notion that would in some way have damaged the defence had that information come out is mitigated. It's largely eliminated.
You say, just to be clear, Mr. Carroll, you say the first time, the first indication in the papers is at page 35, which is of the core, behind 4, tab 4, page 35, the appendix, which is the end of the recognition of Mr. Pearce.
Yes.
Where he deals with the fourth identification parade, and then he says, I wasn't to expect to see anyone with any facial hair, and he's talked about the guy picked at a goatee beard. The guy in the leather jacket who kicked the boy in the night didn't have any facial hair.
Yes.
Now, you say that's the first time that...
That's the first time that's mentioned. It's not in a police statement. And so counsel, in response to that reference to having told the police, could well have deployed the prior statements. And indeed, on one view, had counsel the prior statement, particularly the exit statements, in the parade, and even the other prior statements, had counsel not deployed them in the trial in the face of this evidence, counsel himself may have faced a complaint of failing to provide adequate representation in this case.
Sorry, so he mentioned just 4 days after the identification parade, on which he hesitantly picked out the appellant, the problem he'd had with the beard, is that it?
Yes, my lord, but he mentions that to the procurative fiscal, effectively to the procurative fiscal. Now, the precognition, there is a distinction, I should say, between a precognition and a statement. What my lord is looking at here, starting at page 29 of the core volume, is a precognition given to a member of staff within the procurative fiscal's office. Now, that is a process by which the witness is brought into the procurative fiscal's office and questioned by that member of staff about his evidence and perhaps even any prior statements, to ascertain just what it is that witness is likely to say. That document was not disclosed to the defence, and they're not normally disclosed because it's a precognition.
So you wouldn't be complaining about a failure to disclose, contrary to Article 6, because you've not got this?
Not in that. It's not normally disclosed. But what was done in this particular case, it seems when comparing, and this comparison was done before the appeal court, before the hearing in the appeal court, was that the member of staff had the solicitor, Mr. Adam, before him, in the procurative fiscal's office, and the member of staff read elements from this actual precognition.
Yes.
In reading the elements from the precognition, there was no reading of the difficulty in relation to, for example, photographs in December 2000 on the night following the incident. There was no reference in the precognition to that. The reference to the goatee beard, certainly the solicitor would have been aware of that, because there was already, it seems to be a minor issue raised at the identification parade anyway. So there were no surprises there, and there can be no complaint, for example, if the Crown did not disclose this precognition. The defence had enough information from that and were aware of the essence of this issue with regard to the goatee beard. So they knew that, and that information.
Sorry, where do we find that? I'm not following quite what you're saying about that. What was the issue they raised at the parade?
Sorry, my lord?
What was the issue they raised at the parade?
The issue that was raised at the parade was that the suspect was the only person on the parade with facial hair.
Oh, that was raised, wasn't
Yes, it was raised at the parade. And the police officer said that he'd got in someone else, an additional stand-in, but he wasn't going to be changing the format. The parade would continue, and indeed it did continue. And what I say, my lords, is that had there been any unfairness as a result of that facial hair, or any impropriety as a result of it, then the matter would most likely have been raised in an objection at the trial.
Which there wasn't.
Which there wasn't.
Yes.
And there was no real issue taken there. And of course, Mr. Pearce said at the trial that he told the police he had a difficulty about the facial hair, but that is not recorded in the exit statement, so that could have been put to him. And it's not recorded in any of the statements that he gave to the police that he had difficulty over facial hair. The first reference to facial hair was made by the witness to the Procurator Fiscal after that identification parade.
The position, just so it's quite clear about it, what the objection which was taken at the parade was, the accused is the only guy who's got facial hair.
Yes.
To which the reply was, yes, that's so, but it doesn't matter because at the time he didn't have facial hair.
Yes, that's right. And as my lords would see from the photo board that was examined earlier, the photograph of the suspect in position 4, there is no facial hair. And so these matters could have been put to the witness, that he hadn't told the police about facial hair. He could be asked, when did you first raise a concern about facial hair? The matters could quite easily have been explored, and indeed it would be, I think, unimaginable that counsel in possession of the exit statements would not have raised that. So that may have been enough just to tip the balance in favour of the accused in a thin case on identification. So those are my submissions, my lords, and unless there is any other matter.
Thank you very much indeed. Miss Mackenzie?
I also have nothing to add.
Thank you. Yes, Advocate Deputy.
My Lords, on behalf of the Crown, I invite the Court to refuse this appeal. It's no doubt entirely my fault, my Lords, but I'd rather understood that this appeal was taken to this Court on the basis that the wrong test was applied, not that the appeal court in Scotland had applied their test incorrectly.
I think we have to be rather careful what the devolution issue really is. We're not here as a second court of appeal.
Absolutely.
I think that's very straightforward. So the question as to the proper test, as I see it, would be ancillary to consideration of the devolution issue, and therefore it is our responsibility to adjudicate on what the test should be. But I think your position would be that provided we're satisfied the correct test is applied, then it's not for us to re-examine the way it was actually applied.
In certain cases it may be a possibility, but not in this particular case. As I understood Mr Carroll's submissions, he made two important concessions. The first concession, as I understood it, was that the appeal court have in fact applied the correct test, namely the risk of real prejudice. And secondly, I understood him to concede that the appeal court can remedy a failure by the Crown to disclose material before trial. Now, standing both of these concessions, he would thereafter require to persuade this court, as I understand it, that the approach of the appeal court in applying the correct test was either fatally flawed in the way they went about their business, or their reasoning was illogical. And in my respectful submission, he has failed to meet that particular set of criteria. If one looks at the decision of the appeal court, at paragraph 20, at page 25 of the bundle,
Yes.
Mr Carroll read from a passage about a third of the way down the page. If I can start from the beginning of the paragraph 20. The critical issue in our view is whether the principle of equality of arms is breached, and reference is made to the case of Sinclair and Lord Hope and Lord Rodger. It will so be breached if access to the statement in question would have been of material assistance to the defence, as it plainly would have been in Sinclair, so that denial of access prejudiced that defence. It might also be breached if, having regard to the realities of the trial and viewing the matter realistically, the denial of access might have prejudiced the defence. Whether there has been or may have been such prejudice will be a matter for assessment by the appeal court in the circumstances of each case. Such an assessment will not always be a straightforward or easy task, but it will not be an unfamiliar one. The appeal court regularly has to assess whether procedural failures at trial have resulted in a miscarriage of justice. So, my Lords, in my respectful submission, it appears that the appeal court was fully appraised of the matters that they had to consider in applying what is now conceded to be the correct test. And your Lordships have been referred, and I don't intend to read this out at all, at paragraphs 22 and 23. where the court, who had access to the transcripts of the evidence and who listened to exactly the same argument as presented to this court today by Mr. Carroll, considered all of the material before them and for cogent reasons set out the fact that there was no miscarriage of justice.
Well, I think Mr. Carroll criticising certainly the idea that it would have hardly constituted a coup de grace. I think he suggests that that's pitching it a bit high.
Well, whether something is pitched a little bit high or not scarcely meets the test of this court attempting to disturb the conclusions of the appeal court, who have now, on the concession made, applied the correct test in analysing the matters before them. If they've applied the correct test, if they've looked at all the information before them, and if they've arrived at a conclusion, in my respectful submission, for this court to disturb that conclusion would require them to find that their reasoning was illogical or fatally flawed, and it doesn't meet any of that criteria at all.
Well, it may be the same point, but I'm slightly troubled by the phrase "a robust test is required." One's assuming, I think, that there is prima facie a violation of Article 6 because there's a failure to disclose,
yes.
And one's then looking at the essence of a fair trial. And is it right to say that you've taken a robust approach to that? In other words, you've got to have a great deal of persuasion that something's gone wrong before you could say that there had actually been a failure to provide a fair trial?
Well, the test of a real risk of prejudice is robust, because the alternative is a flimsy test, and I don't think anyone's suggesting that. It has to be a practical, working, realistic test that allows the court to assess the material before it. And whether that is described as robust or not, in my respectful submission, is not particularly the point at issue. The question is, what is the test they actually applied? And the test they actually apply is the real risk of prejudice.
Has anybody used the adjective robust before?
No, I'm not aware of that having been used before, and that may mislead parties. I can see how it can happen, into thinking that somehow the bar has been raised substantially. But it isn't, because they set out what the test is, and it's real risk of prejudice. And I would have been tempting to persuade the court that that was an entirely appropriate test to apply.
What does the adjective robust contribute to the application of the test?
Nothing. Nothing.
So it was superfluous.
Absolutely. It didn't have to be said at all. It'd be better if it hadn't been. But more importantly, they have set out the test they did apply. If they simply set out that we're applying a robust test without telling anyone what it was, that might be one point. But they set out the test, and the test, in my respectful submission, is an entirely appropriate one.
What about the use of the word might in the sixth line of paragraph 20 on page 25? Initially, the word is would have been material assistance to the defence. And then in the next sentence, it might also be breached if, having regard to realities and so on, the denial of access might have prejudiced the defence. And then they come back to have resulted in a miscarriage of justice. There's a slight,
absolutely.
A slight inconsistency between these various phrases.
In the second sentence of paragraph 20 was, it will so be breached if access to the statement in question would have been of material assistance, so that denial of access prejudiced that defence. It might also be breached if, having regard to the realities of the trial and viewing the matter realistically, the denial of access might have prejudiced the defence. So as I understand it, starting from line 2, the court is recognising it will so be breached if access to the statement in question would have been of material assistance to the defence. And to illustrate that, they refer to Sinclair, where my lords, in fact, went on to come to the conclusion that there was actual prejudice demonstrated in that particular case to the appellant. So, my lords, in my respectful submission, looking at the way the matter is set out in paragraph 20, the court is familiar with the matters that it has to consider when deciding or not whether, in this case, a real risk of prejudice was made out. And they do so by reference to the evidence the position set out by Mr Carroll today as he did at the appeal court, and with reference to the various identification parade reports and the photographs, and they came to the conclusion that there was no support found for there having been any miscarriage of justice, and there was no real risk of prejudice to the defence. It was, in my respectful submission, that was a conclusion the court was entirely entitled to reach, based on the material before it.
I wondered whether you could enlighten me about the last two lines on page 25, because I have the impression that the court's a little irritated by the use that people are putting Lord Rodger's observations to. Does that lie behind the reason why permission was given here, that they want us to clarify something? Because I think we do need to be told exactly what it is that is troubling them.
As I understand the position, my lords, some counsel have attempted in additional evidence appeals to attempt to persuade the court that somehow there's a very low threshold in terms of the materiality test to be applied. Now, my lords will have read the statement of case for the respondent, where there is an analysis of what Lord Rodger said in Holland. And perhaps I needn't go into it, standing the concession now made, but in my respectful submission, Lord Rodger was not setting any low threshold of materiality.
Can you just identify what this mistaken reading of Lord Rodger's speech has led to? I mean, what is the low test that it is suggested it stands for?
I suspect it's a mere possibility.
The suggestion is...
Where do we find the language used and the test that's asserted to result from?
It's Sinclair paragraph 37.
Sinclair paragraph 37 and...
Of what? Your case?
Yeah, and in Hogg against Clark also.
Sorry, paragraph 37 of your case?
Well, no, I'm referring to the decision in Sinclair, which is in tab 30 in volume 2, I think. We should really look at that, I think, just to be quite sure.
Sinclair's in Sinclair.
That's Sinclair.
And I believe, is it 37 or is it... No, it's further on.
Well, he doesn't start till 39.
No, I'm sorry, I've got the wrong reference. It must be in Holland.
It is in Holland, I think.
Yes.
Holland, is it?
It's Holland.
Where's Holland?
Holland is tab 9.
Tab 9. Paragraph
70 something.
Paragraph 37, is it?
And I think reference is made to the opinion of Lord Rodger.
Paragraph 82.
82?
Yes.
I think it's 82.
And if I can just deal with that particular paragraph, and the Lords will bear in mind that the case of Holland dealt not only with issues of non-disclosure, but also dealt with issues of identification, particularly doc identification, and also issues of previous convictions, if I remember correctly. And at paragraph 82, it set out that clearly if the appellant's convictions had been revealed to the jury, this might have well been a disastrous consequence, to adopt the Lord Justice Clark's description. But given what Miss Lynn said in evidence, and Miss Gilchrist's claim that she did not know what was meant by gear, and I am unable to say that cross-examination of the complainers about the outstanding drugs charges would inevitably have led to the Crown being permitted to cross-examine the appellant on his previous convictions. Information about the outstanding charges might therefore have played a useful part in the defence effort to undermine the credibility of the Crown principal witness on charge 2. At least that possibility, he says, cannot be excluded. One cannot tell for sure what the effect of such cross-examination would have been, but applying the test suggested by Lord Justice General Clyde and Hogg against Clark, I cannot say that the fact that counsel was unable to cross-examine in that way might not possibly have affected the jury's majority verdict on charge number 3.
I mean, the situation was that it was a very material thing in one sense, because here she was saying that she didn't know what gear in this sort of drug-related sense was, and here was, an outstanding charge relating to drug offences. And the only reply to that, which had come from the Lord Justice Clerk, if I remember rightly, was, oh, well, it would have been very risky to raise that because you would have been open to cross-examination on your prior convictions.
And that was plainly wrong,
and we
on one view.
said on one view, at least the view taken there was that within the scope of legate, it was unlikely that the Crown would have been permitted to do that, and therefore it would have been something which could have been used, deployed by the...
Now, it's that very select passage that has been used out of context in grounds of appeal before the Criminal Appeal Court in Edinburgh to found a basis for presenting an appeal with what is said to be a very low threshold, low materiality threshold.
Is it right
But more
to say,
importantly...
can I just catch you before I forget? If you turn back to page 64, paragraph 64, Lord Rodger's referring to the various tests one uses to see whether things should be disclosed, information which is likely to be of material assistance, likely to be of real importance, and so on. So that I have the impression that that same phraseology is being used here just to stress that this is material of that character.
Correct. And
so it's being misapplied, really, taken out of context.
It's been taken completely out of context. And to be entirely fair to Lord Rodger, paragraph 43.
43?
About halfway down, where the sentence begins, but the ultimate question.
Yes.
And what he says is this, but the ultimate question is whether the trial as a whole was fair. And that question can only be decided by the same court considering all its relevant strengths and weaknesses, including any breaches of specific safeguards in Article 6, together. It follows that, although the issues relating to identification and non-disclosure were argued in sequence at the hearing before the board, in deciding whether the appellant can be said to have had a fair trial, the board must consider all the relevant elements together. So, my Lords, in my respectful submission with Lord Rodger dealing with the issue of doc identification, paragraphs 47 to 63, non-disclosure of outstanding charges, paragraphs 64 to 75, and the failure to disclose a remark made by a witness at paragraph 76. He then, correctly, in my respectful submission, at paragraph 77, again sums up the position, saying this: it is now necessary to consider whether, taken as a whole, the appellant's trial was fair in terms of Article 6.1, and that's with reference to paragraph 43. So in other words, in my respectful submission, he plainly speak for himself, but in the paragraphs to which I've referred, balancing the various factors, he had regard to all of these which had a bearing on the overall fairness of the trial. And insofar as he refers to Hogg against Clark, in the context of determining the significance of one of the supposedly unfair features, the non-disclosure of certain information, in my respectful submission, no conclusion at all can be drawn at this point in the opinion that the proceedings were unfair solely on account of that one factor. And it has to be put into the context of what he said before and what he said later. And it was only when taking all of the matters together, and he again, at paragraph 85, repeats that.
Yes.
By saying, taking all the relevant factors together, I have reached the conclusion that in this case, the failures of the Lord Advocate's representatives to disclose information to the defence and the Advocate Depute's reliance on the doc identifications of Gilchrist and Simpson were incompatible with the appellant's core Article 6 Convention rights. Taken together, they resulted in an unfair trial. So as I understand a proper analysis of what His Lordship said, he makes it plain that it was the cumulative effect of all of the factors taken together that led to the conclusion that the trial was not fair. And what I would invite this court to do is to come to the view, for purposes of clarity for those who seek to seize upon that particular passage to which I've referred, is to come to the conclusion that His Lordship was not stipulating that the Hogg against Clark test should be used in order to determine whether there had been a miscarriage of justice or unfair trial. Rather, what he was attempting to do, correctly, my respectful submission, was considering whether the non-disclosure of the outstanding charges was so unlikely to have been of practical effect that it could be left out of account altogether, as opposed to whether it forms part of a cumulative evaluation. So, my Lords, to answer my Lord and the Chair's question about how this matter has come to pass, it has come to pass as a result of that particular remark by His Lordship in the paragraph to which I have referred, being taken entirely out of context and applied to grounds of appeal, in particular additional evidence appeals before the Criminal Appeal Court in Scotland.
Now, you just used that phrase, which I was going to ask you about. You used it earlier, additional evidence appeals. Am I right then in understanding that in practice, the appeal court looks on these cases of non-disclosure when one sees evidence that should have been available for use in the same way as they have traditionally dealt with additional evidence cases?
Yes.
We've got an example in tab 1, I think.
Yes.
It's a very familiar case of Cameron.
Yes.
And we don't need to look very far than just the holding at the very beginning.
Your Lordship is absolutely correct. Your Lordships may know that Section 106 of the 1995 Criminal Procedure Scotland Act.
So, Section 106 of the 1995 Act?
Yes.
Yes.
It's 106,
Yes.
3 and 3 large A. Provides that, and it's in the, one can see that found in volume 3, tab 57, for the Act as set out.
Thank you.
Sorry, what are we looking at?
Volume 3, tab 57, one sees the 1995 Act, section 106 set out.
Yes. Which bit of it?
So it's really, it's the very bottom of the page.
Yes.
It's subsection 3A.
It's 106, 3 and 106, 3 large A.
Is it a miscarriage based on... Is it large? I thought it was at the very bottom of the page. The person may bring under review any alleged miscarriage of justice, which may include such a miscarriage based on, little a,
Yes.
The existence and significance of evidence which was not heard at the original proceedings.
Yes, and also 3 large A, which deals with the reasonable explanation as to why it wasn't so heard.
Oh, I see.
So it's the bottom of the page and just over the page. And in summary, my Lords will be aware that if in Scotland an appellant provides a reasonable explanation as to why evidence is not heard at the trial, and plainly the Crown not disclosing that falls firmly into that category.
Yes. Well, that brings me to the point I was really trying to get at, which is assume that one has got over subsection 3A,
Yes.
and the court is then feels itself entitled to look at the
Yes.
evidence, then the question is what test does it apply there? And is it sensible to think that there should be a different test where the fresh evidence is really evidence that was not disclosed as opposed to evidence that was simply not available because it was undiscoverable at the time of the trial?
Yes, and it is correct to say that they shouldn't be treated differently, because otherwise one would have one test before the Court of Appeal in relation to issues of non-disclosed material, and at the same time a different test for material that comes to light after a trial pointing towards someone's innocence that wasn't in the Crown's possession pre-trial. But one would have a different test for each of those, and plainly
You
that...
could just perhaps, one could take the view that one of them involved a violation of Article 6 requirement for equality of arms. I mean, there has been ex hypothesi fault on the part of the prosecutor in not disclosing that which should have been disclosed.
Right.
I'm not saying that should necessarily take you to and lead you to a different test, but I mean, there is that distinction between them. It may be that it's just...
There's a distinction. The question is what test one applies to the material rather than...
Of course, I entirely see that.
And of course, it's been accepted already, must be in terms of the decision of Edwards, that this court would require to consider the proceedings as a whole, not just merely the trial proceedings, but the decisions of the appellate courts.
Yeah.
But I mean, on the very much narrower point arising from Lord Rodger's judgment
Yes.
in Holland, I mean, I think having now seen that, I actually can understand what Lord Justice Clark, is that who it is, was saying, paragraph 20
Yes.
in this case.
And
I mean, somebody was, because you could, I mean, if you just look at paragraph 82 in isolation, you ask, that possibility can't be excluded, and then you can't say that something might not possibly have affected the verdict. I mean, you can be using that
Correct.
either as meaning couldn't conceivably, which would be a very low test indeed, or might not, as a reasonable possibility, have affected, which is a perfectly sensible test. And
Absolutely.
it equates to a real risk.
it would certainly be of assistance for this court to make it clear in any judgment they may wish to produce in this case that the isolated paragraph to which we've been referring was not stipulating in any way that was the test to be applied when considering a miscarriage of justice.
I take it, I'm just looking at it, Debbie, but would I be right in thinking that we don't actually have the section which deals with allowing appeals?
No.
I mean, it's the only puzzling part of the whole of the 1995 Act is that the sections relating to appeals are set out in a very odd order, and I think it's defeated whoever compiled this, because the one thing we don't actually have is the section which says that the only ground, it says something to the effect that shall, if there's been a miscarriage of justice, and otherwise will dismiss the appeal or something like that.
Yes, and in fact, just to put, is my Lord referring to Hogg against Clark, or simply just...
No, just the section, the statutory power, the power which the court exercises when it allows an appeal. I mean, we've got the grounds of appeal, but we don't actually have the section, unless I'm mistaken, we don't have the section which actually gives the power to the court. There is a section which says the powers of the court on the appeal or something.
Yes.
Am I wrong?
No, your Lordship is correct. But,
Are they different from what we see, although the numbering is different from what we see at page 251 in Cameron, tab
I don't
1?
think it is. No.
Because we can see 228, which I think is the predecessor of 106. It says what you may bring under
yes, it's
review.
volume 1, tab 1. Cameron, in 1991, Justiciary cases, page 251. And Lord Justice General Emsley, page 262.
Oh, yes.
Paragraphs 132 and 133.
Sorry, where in Cameron are we looking?
We're looking at paragraphs 132 and 133.
I haven't got any paragraph numbers.
You don't have that. It was the old reporting system with no paragraph numbers. You get paragraphs in Cameron.
Sorry, I'm not. Okay, sorry. Once you finish this out, come back to me.
I don't have a judgment long enough to get to paragraph 100 and anything.
You just
Do I?
I've missed where we are, sorry.
That's an additional evidence case.
If one looks to page 262, about 6 or 7 lines down, which starts, "What then are the circumstances?"
Yes.
Yeah.
Question mark. "In our opinion, they must be such that the court is persuaded that a verdict returned in ignorance of that additional evidence must be regarded as a miscarriage of justice. Plainly, the court will require to be satisfied not merely that the additional evidence was relevant for consideration by the jury. Setting aside the verdict of a jury is no light matter, and before the court can hold there has been a miscarriage of justice, it will, under reference to the language of section 2282, require to be satisfied that the additional evidence is not merely evidence which should have been relevant to lead at the trial, but that it is relevant evidence of such significance that it will be reasonable to conclude that the verdict of the jury reached in ignorance of its existence must be regarded as a miscarriage of justice. The decision on the issue of the significance of the additional evidence is for the appeal court, and before the court will be in a position to decide that the verdict of the jury represents a miscarriage of justice, it will require to be satisfied that the additional evidence is important evidence of such a kind and quality that it was likely to have been found by a reasonable jury under proper directions of material assistance in their consideration of a critical issue which emerged at the trial.
That's a fairly robust way of putting it, isn't it?
It's set out very firmly, but it has been followed on a significant number of occasions by various...
It obscures the test, it seems to me, very effectively. I mean, you ask whether the jury would have found it a material assistance. What does that mean? They wouldn't have just simply said, well, for heaven's sake, why are you wasting our time with this, or what?
I think it means a real risk of prejudice. A real risk of prejudice, namely material, which was not before the jury, which causes a material disadvantage to the appellant and produces a doubt which isn't fanciful or speculative, but is reasonable.
Well,
So
it may be...
it may be expressed slightly differently than a real risk of prejudice.
And yeah, I have a feeling it's been examined once or twice, this question, since Cameron, has it not?
Yes, it has.
Has it not been examined in lots of cases?
There are a number of references in the statement of case for the respondent to other cases where issues of fresh evidence have come before the court governed by the provisions to which I've referred, and some have been successful, some have not been. And the Lords, in my respectful submission, when one is looking at non-disclosed material by the Crown, it is entirely appropriate that the court can look at that material as if it's dealing with fresh evidence appeals.
Well, I'm just wondering whether that is really right. I mean, as Lord Brown was pointing out, the starting point of this particular chapter of that part of the criminal jurisprudence is a violation of Article 6 and the requirement that it should be a fair trial. And if there's a real risk of prejudice, going back to the phraseology we were using before, one can understand that.
Yes.
Maybe it's muddling it up too much to get involved in the Cameron test and so on, where you've got to get through a different hoop to get there. And it's the appellant himself who's trying to adduce fresh evidence, not complaining of a non-disclosure. I'm just not certain about that.
There are a number of cases that come before the appeal court in Scotland which are cases which involve non-disclosure. Some are presented as fresh evidence cases, and some are simply presented to the court that it was a breach of Article 6. And so they come before the court by different routes.
It could be for different purposes.
For
fresh
different
evidence
purposes.
would be straightforward evidence that you would want to have led.
Yes.
A non-disclosure case such as the present is one which is really concerned with additional ammunition for cross-examining a Crown witness. And these may lead to different...
Well, it's certainly
conclusions.
all of the fresh evidence appeals that proceed on the basis of a concession by the Crown, that they fall into that category. And there was a reasonable explanation for the appellant not having such material, because it was only disclosed to him after conviction, plainly.
I think it's implicit in your submission, but I'd like just for my own part to be clear that you accept that in order to constitute a real risk of prejudice, the effect of withholding material does not need to partake of the quality of a coup de grace.
Absolutely.
I'm not sure coup de grace is entirely the appropriate expression. My understanding of that is a merciful blow, but on an already weakened victim. Was the appeal court referring to a knockout blow?
Yes.
Yes. I have to say, Lords, that expression, with the greatest of respect to His Lordship, delivering the opinion.
But it's a throwaway line.
It's not helpful, but it's a throwaway line.
What he says, it's really, just so to speak, knocking down a skittle that really shouldn't have been put up, because he uses could hardly have constituted. I mean, you really can't read, at least I would have thought it would be difficult to read into that the additional words which it would needed to have been to have availed the appellant.
No, I mean, of course, the allegation in this case, of course, is one of attempted murder, and coup de grace is suggestive of a killing, and of course nothing of the kind. It's simply been knocked out. So it's perhaps not the most helpful of expressions in the context of analysis of the appeal reasoning, but it is, in my perspective, it doesn't detract at all from what I said earlier about the approach the appeal court took to it. Well, can I say this, that, and I can move on very quickly, in the various cases before it, the appeal court of the High Court of Justiciary has always required non-disclosed material to meet some threshold of materiality. Whatever formulation is used in whatever number of different ways the court chooses to express itself, in my respectful submission, they all, I think as Mr. Jackson said in the McInnes appeal this morning, they very often all come to the same thing. They all come to whether there has been a real risk of prejudice to an appellant, because it could hardly be said, and not logical, for someone to claim that his trial was unfair, but in fact suffered no real prejudice. That would not be logical, in my respectful submission. So someone could not claim his trial was unfair if he was unable to demonstrate that he had suffered some real or realistic or reasonable prejudice that would have affected the outcome of the proceedings. And all of the various tests and all of their various formulations.
Which would have affected the outcome? I don't know, that's pretty very high. It might
reasonably have affected the jury's decision. That's the Pendleton test. I hesitate to put in a plea for some sort of consistency across the border. But I mean,
well, of course, I'll be inviting the court not to come to the view that consistency across the border is necessarily useful or appropriate. But certainly I take my Lord's point that in all of the jurisprudence in a number of different jurisdictions, that generally is the kind of approach that's taken. In American jurisprudence, it's a reasonable prospect of a different result, for example, and is also consistent with the approach taken to fresh evidence in England and Wales, where the Court of Appeal considers whether the evidence given at trial might reasonably have affected the jury's decision to convict. So I take entirely Lord Brown's point in relation to that. The formulation of the various words used effectively amount to the same thing, that there has been prejudice caused to the appellant in his trial that might reasonably have affected a jury's decision to convict him. And frankly, if the court in Scotland were to keep the matter simple and consistent, it would be of use to everybody, including this particular court. And in my respectful submission, eventually alighting upon the words real risk of prejudice is a perfectly sensible and practical way of remedying any defect that has occurred in the original trial. My Lords, I don't wish to take the matter any further unless my Lords wish me to, but I would invite them respectfully in relation to what Lord Rodger has said, if issuing any judgment in this case, to make it clear that those remarks to which we've been discussing have been taken out of context and should not be in future cases. And that may be of assistance both to counsel drafting grounds of appeal and to the Court of Appeal. I would also invite them to come to the conclusion that the test alighted upon by the appeal court, namely real risk of prejudice, was entirely appropriate and was compliant with Article 6. And I would also invite them to come to the conclusion that in applying that test, they did so correctly, providing cogent reasons for their decision, and that they were entitled to reach the conclusions that they did upon that material. And Lords, I've heard what I have to say about issues relating to fresh evidence appeals and how there can be a consistency between the various tests, albeit expressed somewhat differently in their terms. And on that basis, to come to the conclusion the appeal, as currently set out and argued today, is without merit, and to refuse this appeal.
Thank you very much indeed. Mr. Balfour?
I have nothing to add.
Yes, Advocate General.
Well, I can be extremely brief. I should say I was initially tempted to critique to a degree the observations made on behalf of the respondent in the respondent's case dealing with the role of the Supreme Court, where it seemed to suggest that the Supreme Court in its approach might be equiparated to that of the European Court of Human Rights. I'm assured by the Learned Advocate Depute that those observations in paragraph 6 and 7 of the case are were to be specific to this case, and he has not relied on them in this case. Therefore, the sense of being tempted to critique has perhaps flown away, and in the light of the approach adopted in Allison this morning, the exchange between the Lords and the Advocate Depute indicating the role of the Supreme Court, it perhaps is wholly unnecessary.
Could you just help me to understand what you just said about paragraph 6 in particular of the respondent's case? When we're asked to follow a similar approach to Edwards, we're asked to consider the proceedings as a whole, including the appeal process. Are you disputing that?
Lord, no. It's where it continues it should consider whether the procedure before the appeal court of the High Court of Justiciary remedied any unfairness at the trial stage. In so doing, it need not make its own assessment of the facts or the evidence, those being matters primarily for the Scottish courts. Now, in relation to that last point, it can, of course, be open to Lords to make an assessment of the facts if they are so minded to do in the interests of justice. And that is really the point that I raised in relation to Allison, and which formed part of the exchange between the Lords and the Advocate Depute in Allison. There seems to be some suggestion there that the Supreme Court is limited in its jurisdiction when matters come before it, and that, in a sense, the facts are to be left only for consideration by the Scottish court. Now, I do not understand that to be the proposition that is being advanced as a generality.
You say, in other words, that if one came across, I'm not suggesting it would ever such thing would happen, but if one came across a case where the appeal court had purported to apply an appropriate test, but had gone about it in such a way as to abuse it in a sense, and therefore, although nominally, if it was applied correctly, it would remedy the whole situation, there could be a situation where, if it had failed to appreciate, to do a proper, and had done a perverse appreciation of the facts in that situation, even though they are purported to apply the correct test and all that sort of thing, which, if applied correctly, would have led to the thing being remedied, in that situation, this court could indeed interfere, you would say.
Precisely so. My Lord inevitably puts it better than did I.
The context for that will always be a devolution issue, though, won't it?
Of course.
And
Yeah.
I suppose the basis for your argument, if one takes it all the way back to base, is that this court is under a duty as any other court is to apply Article 6.
Oh, yeah.
So that in the resolution of the devolution issue, we have to be satisfied that there has been a fair trial, and it's part of our function to provide that if we thought that hadn't been achieved.
Precisely
Would that be right?
so, my Lord. Precisely so.
Anyway, you're not really suggesting that that particular problem is arising here, are you?
Lord, no. It's just if this passage were intended to be offered as a generality, it has been clarified with the Learned Advocate Depute that it is not offered as that.
Yes.
So that is why I don't go further than that. The only other point I would make is really by way of comment. Again, as the Learned Advocate Depute has set out, there is a real need for clarity in particularly the area of disclosure, because of the approach which is taken to the speeches of my lords in the Judicial Committee of Privy Council cases, that they're approached on apparently a conveyancing analysis, which leads to, if not confusion, at least to considerable fine arguments made frequently before the courts, and which no doubt will end up in certain guises before my lords. So that is why I ally myself with the learned advocate depute in the desire for clarity. I should offer one observation, that where words like robust are used, they will be provided with a meaning by the way in which they are assessed, and it will be somehow seen to mean something firmer or stronger than materiality. There is plainly, again, a risk that that will happen.
You don't want us to use the word robust, you mean?
That would be a plea, my lords. My lord, the word robust is used by my ministerial colleagues day and day. And I can then understand why it may be said it has no meaning in certain quarters. Yes. But it will, as a matter of law, doubtless be seen to in some way elevate a test in some way. So that would be a plea, my lord, rather than an argument. Lords, I have nothing further to add.
Thank you very much indeed.
Lords.
Mr. Carroll.
Very briefly, my lords, in case there's any doubt about my position on this matter, the learned advocate depute said that I made a concession that the court identified and then applied the correct test. What I did say, and I've checked the notes with my colleague, is that I conceded they certainly identified the test, but I said they misapplied it.
Yes.
So in effect, I suppose, a metaphor is having the correct horse but putting the wrong rider on its back.
Yeah.
And as a result of that, it effectively neutralised the whole process. The second point, my lords, very briefly, is I do not submit or accept that examining fresh evidence appeals in terms of the Criminal Procedure Scotland Act 1995 offers a great deal of assistance, because in relation to non-disclosure, for example, I think my Lord Brown identified the point perhaps, my Lord, in the chair identified the point, I think it was, that a fresh evidence case is looking at something that was never before the court. Whereas in a case such as this, where it's withheld evidence, it could in fact be more of the same, but the sort of material that could tip the balance. Where, for example, one witness says another witness is incorrect, but if there's a battery of witnesses who are not disclosed, say that witness was incorrect, that's not fresh evidence as such. It's quite a different, it's a different animal. So those are the only points I'd wish to raise with my Lord. Yes. My Lords. Obliged.
Well, the Lordships are very grateful to Council for their assistance. They will take time to consider their decision.
Yes.